Give the point. If the defect as pointed out by the stamp reporter is not removed within 2 weeks from date, defects as pointed out by the stamp reporter is give.
Actually, I cannot been not present.
File memo. Not pressed. Dismissal.
Item number 4.
Which order is sought to be reviewed? 13.9.
Let me give you also the background of the case.
Which order is sought to be reviewed?
So the order is also
Dated?
Case 43.
20th of March.
So it is
20th of March.
2023.
Yes, just
The Honorable
1
Court
minute.
has not decided the matter.
Just 1 minute.
Sir.
Yes, sir.
But the Honorable Court has not decided the matter. He has referred to.
No, decided.
Sir,
On the ground of delay in latches.
the delay actually, exactly. But I just wanted to explain also. I have explained the delay in the writ application. That has
Where is
not
the
been
writ
taken
application?
into process. In the corrected writ application, I have explained the dilemma.
Where is the writ application?
But so can you look at the writ application of this 133 of 2017.
Yes, let us see.
At page 20, paragraph 31. The lawyer actually who was looking after, he expired in the meantime. That was 2015. And therefore, it could not be communicated to him. And subsequently, when it was known, then special copy was obtained.
The petitioner is a company or is an
It's an
individual?
individual. Let me explain it also. This is Nazrul lease. So this Nazrul
What is this
lease-
Nazrul lease?
Nazrul, sir, actually in Orissa, the 4 types of lease there. One is Hasmal lease, which is
Hash Mahal is a different concept.
right. No, this is in the OGLS Act, they have defined all the leases. So this is Nazrul lease or HON'BLE. This is all heritable and transferable.
No, what is the nature of that lease? The lease
Nature of the
granted,
lease actually 30 years lease. It extended from time to time on the application of the party concerned.
so is a settlement of a land
Settlement of
through
the
a
land.
lease.
By virtue of the lease. Now
And
they
which
have
is
to get freehold.
extendable or renewable
Yes.
for another period.
Right, another period of 30 years.
Okay.
Now, government actually, in the recent past, government has issued to make it
Is in
freehold,
respect of a homestead land or in respect
homestead land.
homestead?
Absolutely. Homestead, construction of building is there,
Yeah,
homestead land. So it was initially my ancestors were the leasing. Subsequently, I have given description in the annexure 1 of the rate application. But it was subsequently they applied. Then government wanted to acquire a portion of it, saying that no, 1 acre 38 is the original leasehold area. So you are not entitled to the entire amount of property.
Entire area.
Behind the area. Part of it was taken away. So
Okay.
only 88 decimal remain. The other part taken over by government collector. Other part collector recommended on inquiry and all their paraphernalia they have made. And it was recommended in my name. It was settled. Lease deed was executed. To the extent of lease deed has also been executed in my
In
name.
respect of 88 decimals
Right.
of land.
That was not the subject matter of challenge.
Okay.
4 individuals, independent bodies, they filed appeal 4 years after. What they wanted to say, since a part of it has been leased out in favor of me, the other part they are in possession, it should be leased out in their favor. While deciding their independent appeals, the court has observed the lease in my favor is also bad. It was
Which
not
was not a subject matter of challenge.
no. But they say that this X has been granted, we are in possession, we should be granted the lease. So that was the subject matter that was dismissed by the Honorable Court. That no, you don't have a right. A lessee can have a right. You can't have a right. Because it's heritable and transferable and
Then
that.
what you did against that order?
So that order is there. If you are
No, what you did against that order?
sir,
What you did against that order?
we are challenging. That order is a subject matter of challenge.
No, that order was passed when?
Initially 2011.
So,
That was challenged in writ, remanded. Again, it was heard. 2012 order has been passed.
correct.
After the 12 was passed, those appellant, they challenged it. So that was dismissed. The Honorable Court has taken note of those cases, saying that it is covered.
No. There was certain observations which was made by the writ court.
Right.
Writ court while dismissing their writ petition.
Yes, in their writ application. In their writ application, where the appellants were there.
Correct.
So, sir, though I was a party in that
No,
writ application.
Correct. So
but
did you
no-
challenge that order?
Sir, I was not just no notice has been given. So
No, but you were a
did
party to the proceeding.
I did challenge that. Reason being, it was filed the appeal.
Why? There was an observation which goes against you.
Sir, the 17 is the 2017 I filed the writ. That order was challenged in 2017 by me. That is
That order of the writ, that order of the writ court
writ court.
of 2012 was challenged by you in 2017.
No.
Then
So I challenged the appellate order
true. What was the appellate order? Appellate order means by an authority.
by RDC.
What he decided.
He decided that all the appellant's case is rejected, so they are not entitled to settle. Vis-a-vis decided the lease granted in my favor is also cancelled.
So that is the appellate court
Yes.
or appellate authority.
RDC is the highest authority.
Correct. So the appellate authority's order was communicated. You were a party in that
I was a
proceeding.
party.
So why you did not challenge that appellate authority's order?
Paragraph 31.
30s.
The only explanation, I'm a party actually. I depend on the lawyer. But here I challenged. That was notice was issued.
When the lawyer died.
So not 2014. 2014. I've indicated the date also. Para 30.
He did not communicate to you that the revisal application is dismissed on that day.
The explanation I can give, and truthfully, I
Then what is your explanation for next 3 years? You said that the order was given to you later on, but the gentleman did not intimate you.
haven't indicated that order was communicated. to
Is
me.
it?
Then I immediately went to his office. His office actually, after his death, his office was closed. Then I got the certificate copy he had already obtained. then file the writ application. Now, you have noticed in the writ application,
Sir, the order was passed in 2012. Certified copy must have been applied in 2012.
Immediately
The
got it.
it is obtained in 2012. He died in 2014. 2 years explanation.
sir, only thing is I would like to submit for also means this Honorable Court entertained the writ applications. You should notice. After it was contested,
Oh, you wanted to say that once you have issued a notice at
sir,
the
this part
contested
is
stage, you cannot take a plea of delay and
like a
laches.
delay. The Honorable Court has issued notice. They wanted to hear it on merit. On merit, he said, already decided. Actually, that is not the case. It doesn't stand as a resident.
Is it not a rehearing or revisitation of the order?
Sir, rehearing has to be done, so that's my prayer.
Can it be done in a review jurisdiction?
If the court has not, number one, taken into consideration the explanation I have already given, simply says delay. This is
If
one part.
that means can we not construe that the court has impliedly rejected the explanation or did not find that explanation to be sufficient?
Your Worship is absolutely correct. But question is, court has not indicated that.
No, that
Here,
is not required. Implied, there are express way of doing it,
I
implied way of doing it.
But here-
Implied does not mean that he has to write.
Here actually what has happened, Honorable Court has taken note of the fact that since similar matters have already been dismissed, number one, I don't want to entertain, that was close my case on merit also.
I understand that point
Secondly-
may not be, but so far as a delay, if the court has said that delay, then in that event,
the face of
it may be an erroneous order. What do you say? But
No, I
it
don't
can't
see
be.
the erroneous, but court has
But
lost
can't be an
my-
error apparent on the face of the record.
Something which is on the record, I think the court would have simply said that, no, they have explained, I don't
But
accept.
one
it.
line that implied, when a court simply issues a notice in an injunction matter
Substantial right.
and without granting interim order, does it not tantamount to refusal, implied refusal?
I got on the substantial right is going to be affected.
Maybe, sir. Review jurisdiction, is very limited.
But review jurisdiction, I understand that the only point I can canvass before Lordship is, I have indicated, court can look into the matter if the court has not considered it. Some materials are there on record, but it has not been considered. And on the face of it, the Honorable Court has not, with due respect, applied mind to consider it. They simply said 5 years delay, dismissed. Now 5 years delay has been explained. But it is not that I came with a close mind and close hand.
No. That's the.
So only on merit paper is considered.
Was a party to the order.
Well, that
So
is
you
one-
convince him.
Well, that is one of the ground where it should be.
Now, para 4 and 5, we have taken consideration of your submission and accepted the contention of additional government advocate.
Correct.
So consciously we have done that. So where is the scope of review subject to, I am again.
The question of review I am raising, the legal question here is, that the cases referred to here do not relate to or subject matter of dispute for the appellate court.
That may be an erroneous consideration. Again, I'm saying, you know better. There is a gulf of difference between an erroneous order and an order suffers from an error apparent on the face of the record. So these are two distinct factors. Erroneous order, you can go up, challenge. But so far as the error, review is very limited because you are not coming under B, discovery of new and important documents. Without due diligence, you could not. And the third one is not that omnibus where we can imply for any other substantial reasons.
But here,
We can't invite those. judgments are this last clause must be relatable to the others clause.
But I think Justice Raman was also there, with Justice Sarangi, in fact.
No, the first petition, you are the opposite party.
Yes,
So that was remanded. And you participated in that.
yes.
So constantly you have participated.
That what I brought to notice, this was not the subject matter. My list was not the subject matter.
No. In the first read, you are the opposite party.
Yes, sir.
Yet when it was relegated to RDC for rehearing, so you participated. You participated, and you suffered an order there.
So that is what I have challenged.
So
But that is what I am before your lordship. But because my leave does kindly have a visual.
so that also emanated from other
No,
cases.
you have a very good case on facts. We can appreciate it. That what was not the cause of action for initiation of a proceeding, the court cannot go and decide something else.
But,
I appreciate it. Because the cause of action was that seeking a parity. Since you have been settled with the lease of a portion of the property,
Yes.
then why not the other portions which is carved out from that particular lease should also be settled with them. I understand that was the cause of action. In that case, probably I may agree to some extent that there was no question of deciding whether your lease was bad or your lease was right. But still, we are entangled with the proposition of law.
So law actually, if your lordship looks at it, but After 8 years of filing the writ application when notice was issued, that was hard on the writ.
There are one of the judgments of the Supreme Court. Once we have issued the notice, and then invited the counsel to argue on merit, then it is not proper for the court to discuss the matter of
That exactly is what.
and conscious.
But the Honorable Court actually,
Disputes. I am really, I would say, grappling with the jurisdiction of the review.
but if your Lordship looks at paragraph 65, just one copy. The Constitution built para 65. They have indicated about the fundamental right and civil right, but they have said Article 32 limitations should not stand in the way. Yes. 26.
There cannot in the video matches for the
32 is.
It's a reckoning cause of action. The violation of a fundamental right on each day, on each moment, constitutes a fresh cover.
Absolutely. Para 60. As you can see, para 65 in that judgment.
But so far as the civil right is concerned.
Correct. Para 65, the Lordship explained.
There were
Waiver, estoppel, and acquiescence.
by conduct.
But that is only for that once you issued notice and wanted to hear on merit, and merely because the other two writs were dismissed, this is only application, nothing else. But I have explained, this is not that I have not explained, which was beyond my control. In fact.
That's the very fundamental principle which is reiterated.
Correct.
But it does not really dispense with the other aspect.
But in that case, delay of 12 years has been condoned, but that's
That is a conclusion.
fundamental right.
That is Article 142, or whatever 141.
So there is no straight jacket formula as such, but here actually, no, cases are there where actually if you don't explain.
Had it been a regular appeal, no problem. Had it been a regular appeal, no
The
problem.
only thing I have explained.
But if it is a review, then
Review what I beg to submit, Ballot, because they have only, I think the Honorable Court, Justice Rahul was here, and they could not decide because the earlier two judgments are there staring at me. Actually, that's not the case. So we hear it on merit and you decide it, I'll be really grateful. So the party can get justice with. Lease deed has been executed, all inquiry was conducted.
I understand.
And after the lease deed is executed, they cannot cancel it.
Right of re-entry.
So they can only cancel if there is a violation of the terms of the lease.
Let's say right of re-entry,
Right.
you can forfeit the lease. Either under section 114 relief or 114A.
Correct. But that has not been done here. If delayed substantial right is pitted against each other, or the
Because then the purpose of the Revision Act has to be known. Why the Revision Act is introduced.
sir,
Right is not
I
extinguished.
consider
It's a relief, it is a relief which is denied.
yes.
So right is not extinguished by virtue of a Revision Act. The right remains. But the relief before the court has shut the door.
Here, sir, I have explained. That's only I can say it was beyond my control, beyond the control of the petitioner. And he has explained.
Where are those line of judgments that once the notice is issued?
Sir, there are three judgments are there. It is there actually. I wanted to bring those judgments. And one of the judgment is recent one because the Supreme Court. One. Supreme Court has set aside the high.
That once you have issued a notice.
Yes.
The time of hearing the
So there are three judgments at least. I can give you also. If you are after lunch also, if you are once, I can cite those judgments. It is there. No?
I know. I'm aware of two.
Okay. So recent one is Supreme Court recently in 2025 the order has been passed.
Extension is there with respect to Mazumdar and it is not those type of rules exist. Like the criminal reason point and is in that term. Verify whether the these pieces of inject to them and these things and aspect of was also granted in the market. So whether this is getting to the lease before talked about in other similarly
situated.
so we have just accepted the version of conditional government yesterday. Or that day, saying that the similar matters are discussed. Perhaps you have not examined the subtle distinction between the nature of land.
If you check
Can you please verify that?
verify. Yes, I got you.
I think
Right.
that should
Yes, ma'am. So those are they claimed to grant them the lease.
your perception if factual factually it is not correct.
Not correct.
That paragraphs 5
Right.
is distinguishable. Then I think we do.
Correct.
There are two aspects which we want to highlight in this instance. Because there is a point other has said that the judgments are relatable to a further action which is due for those people in whose favor the leases have they are not executed. They went to the authority for execution of the lease in their favor. Is that was the subject matter of the lease? How can that be applied to him? And where the lease has been granted, executed, and he is in a certain condition. Thereof, this the genuinity, legality, or veracity of his lease was not a subject matter of marriage. If that is the position, how can an authority, has he not exceeded the jurisdiction and then passed the order first? Secondly, the delay that is once the notices is issued, the other side respondents are invited to argue on merit what that the course is taken. Can a court thereafter say that there is a delay in matches? Well, there are judgments of the apex court which
Yes,
says that if the parties were invited to argue on merit, then at the final stage of the hearing, the court would not say there is no delay.
Limitation has to be addressed first.
It has to be at the very first. So on these two counts, it appears that what is established prima facie, it is not it is really a tentative one. It used to be correct. Still, the second, third large issue. Suppose if we find everything is correct, does it come within the purview of the review?
I'll examine the election. It's after the waiting. Yes, Your Lordship. After the.
कितने difference है कितना?
Screen.
Similar to the recent judgment I was referring to is special leave petition 14350 of 22 decided on
Has been there.
January.
January 8th, 2025. Here actually, sir, partly sir, Mr. Utkal Highway, Mrs. Utkal Highway Engineers Contractor versus Chief General Manager.
14350 2022.
Appeal number 15350 of 22.
14.
14.
1-4.
350. 22, 2022. But here actually the Honorable Court, after entertaining the writ application at the time of hearing, rejected on the ground of alternative remedy. Court said, you see, you have entertained the writ application. But there is a reliance has two other decisions are there. I can get it, but I got it. Order 47 is rightly indicated, but only due to some mistake or error upon the face of the or error upon the face of the record or any other sufficient reason. Then it has been explained ages and generis. Right. Para 8 in the judgment, paragraph 8.
Oh.
So that's Supreme Court judgment. Yes, sir. Sir. Alternatives. Right. Because the court once the court has entered.
Of agency, not for relegating a party to a suit for article.
The delay there are
Not desirable.
there are judgment delay also.
Not desirable, I understand.
But
Already gone, but I am talking about the delay also.
well, there is a provision actually, the review actually what your worship has just reading. But it says, number one, the grounds on which a review can be made. One of the ground they have mentioned for any other sufficient reason it is necessary to make a review of the order. This clause obviously means review may be made on exceptional circumstances in furtherance of ends of justice.
That's the note or the commentary.
No, sir, 2008 volume 1 OLR, page 570. The decision is there. I appeal to your lordship's conscience that here 8 years after.
After that, authoritative judgment was not the thing of the Supreme Court.
It is in journalism. I am conscious of it.
These judgments cannot stand. Now, this is not a procedural thing.
Right. But
There are two ways of review. One is the procedural and another is the substantive.
But at the point, as you also rightly point out, the court has entertained that distance are there. I can place with the lordship.
Mikey. 2024 anniversary 314. 2024 anniversary 314.
Yes,
That is on delayed lectures.
Delayed latches where Supreme Court is very strict. But one question is,
Delayed lectures, this only after 220. And this is also some land related methods.
can I just come with those distance? So
there are up till number of judgments not against.
right. Yes, yes, but
that line of discipline is
Your Lordship, may actually those three points, Your Lordship, the orders, and it will be very clarity to get that. Those I have put it down. Okay, Your Lordship, that's it. I've put it down. Let it come after vacations, Your Lordship, around the last week of October.
this is after 4 years. I'll go to that.
It is on delay that means.
4 years delay. But there are judgments also which says
Item 5,
Your Lordship, may post it to last week of October
47.
27th. Oh, bless you.
Item 5,
Last case, I am filing a refill counter. And also the application, I have also replied to his interim application. Last. Yeah. Copy.
In matter, my lord. That is inside. That is, let him argue that matter because that is dependent on, his result will be dependent on this. So he has challenged the order of the update already there. I have only challenged that the interim order, though the interim order was not passed, my mining has been. The first item, my lord, I have I have mentioned because my lord, consideration of the first matter, my lord, I have mentioned because that I have listed because of consideration of the interim order. Because in the earlier, the second writ application, he has filed that challenging the application, appellate order where no stay was granted. Man. Thereafter, but in some letter communication was made by the Advocate General Office to, though lease was executed and I was operating the mine, my mining was closed without any interim order, though there was no interim order. I brought this back to the knowledge of this honorable court. Thereafter, my lord, I filed this writ application. The first writ application, all pleadings are complete, my lord. Let him argue that, my lord. The second writ application, where he has challenged the appellate order because of that.
What is the first petition is concerned?
This is, my lord, with regard to that. I have only my limited years, my lord. Since there was no interim order, and I was.
There is any direction in the first writ matter to file the evidence?
No.
Last writ petition will have. The first writ petition was filed challenging the appellate order. Thereafter, on this petition notice was issued on 17/5/2021 by this honorable court. And the state filed the counter on 7/7/2021. Thereafter, additional affidavit on 23/8/2021. And in the meantime,
What about the first one, 2025?
the 2025 has been filed challenging an order of the Tahsildar of the order dated 5/12/2021.
That's why
We'll file.
you don't have any.
No, we will file.
This.
We will file our counter affidavit. In the first case, we will file our counter affidavit. In the connected case,
So when both are tagged together.
Yes.
In this matter also, you'll have to show your.
yes, we will file a counter affidavit.
Cannot be decided in that isolation and then issues are down. Why do you have to?
We will file.
Application was sent off.
Yes.
And you were instructed to file in September, I think. You know, you are
Yes,
served with a copy. And
You are served with a copy.
response.
We'll file our counter affidavit.
No, only.
May I submit one thing?
On the matter.
If your lordship
In spite of the manner, I became successful. My mining has been stopped because of the some communication from the General Office. That is what is the challenge before this. In spite of that, my lord,
So by grant us 3 weeks time, we'll file the meantime.
Just immediately after the reopening, you will just.
Immediately after.
On
Yes.
9th.
Month.
By 9th, you file it.
Right.
You wonder if any can be filed by the petitioner within a week from there.
For 6.
My lord, this case attention the appointment of president and vice president in Odisha Sahitya Academy by state level organization of letters. The state government appoints president and vice president, but for more than 1 year, no appointment. What are you doing?
Why are you not appointing? If it is a statutory responsibility, we will not state. Is there any kind of obstructions? Is there any kind of inhibition in you?
We will take instruction.
So this repetition is filed, now you should take.
I'll take instruction.
What instruction? There should be a direction to appoint. And what is the statute? What are the responsibilities of the president and the vice president?
Yes, my lord. I have Annexure 1 is the
And
constitution of
as
the.
the general council is concerned, an executive board. Sahitya Academy.
Yes,
There are a lot of responsibilities. They have to take a decision. They have to be part of that particular committee, so it is the entire functioning of that particular academy is.
Yes, madam.
Has come to an halt. Yes. Which statute governs?
Actually, it is governed by Annexure 1, the Constitution of Sahitya Academy, my lord.
I'm just asking, what is the nature of this? I'm just asking.
The Sahitya Academy is a registered body and the
What body? Registered society?
society.
It's a
society.
cooperative, it is
Society.
what, a statutory body? What?
It
It's
is
a corporate body.
It's a corporate.
Corporate body. Well, Lordship,
As it seems from the appointment of president, from the total instructions, the president and the vice president shall be appointed by the state government and shall hold office for the period as the state government will do to.
No, I understand.
page 10. A, small a. That will be academy shall be a.
Who is the
my lord, I am a public spirited citizen
public
and I am a poet also.
Huh?
I am a poet also. I am an advocate.
Poems you have.
I have written many poems and published in the leading journals. And
Reading journal.
my lord, I will produce it. The Honorable Court desires. I will produce. I will file an affidavit regarding my publication. And I take interest in the literary activities. And it is a state level institution of letters, my lord. Sahitya Academy. It is a symbol of Oriya Asmita because it deals with language and literature, my lord. This institution.
I'm concerned about the scope of Article 226. If it relates to an affairs of a society, can you not go to a registrar of the societies and flash whatever the issues which are there? Or should you come straight away to Article 226? I'm just looking in that perspective. Listen, I can understand that the academy or a member of the Sahitya Academy or a secretary of the Sahitya Academy has come and saying that since it is an obligation of the state to
Yes,
acquire, state is not doing. I can understand. You may be a member of the academy, Sahitya Academy. Are you a member?
No, my lord, I am not a member.
Not a member.
I'm only a public spirited citizen
Can
and
you
poet.
maintain PIL for such nature?
PL, my lord, because it is a public institution.
Public
Of
institution,
public
it's a society. It's a society governed by the Society Registration Act. You say it's a society. Is there any statute constituting this academy? Then it is a statutory. I can understand. Let's be. You say it's a society. Must be registered under the society.
Society.
Registration Act. There is a registrar of society.
But because the president and vice president are appointed by the state government,
Or the active promotion of the language and literature is created as an autonomous independent organization in 1970, which takes power to the society.
There is a society.
yes, ma'am. I don't dispute that.
Yes, you take instruction and give it to us. We can't keep it eternally.
No.
2 weeks after.
Madam. Item number 7.
My lord, item number 7. In 15 public universities of the state, my lord, more than 1,300 teaching posts are lying vacant, my lord.
Yes.
And the state government or the universities are not taking any step to appoint regular faculties. They,
In earlier matter, who was the petitioner? You were the petitioner.
I was the petitioner, my lord, because I was an alumnus of the university and at the same time a public.
In earlier matter.
In earlier matter, yes.
You claim yourself to be the poet.
My lord, poet is in the Odia Sahitya Academy matter, poet, a public spirited citizen, and here I am an alumnus of the.
Case of Krista in item number 6.
I don't know, 6 petitioner. I am the petitioner, my lord, petitioner in person.
That's why I am asking. And you say poet.
My lord, because about the Sahitya Academy, my lord, I wanted to prove that I am also a poet and take active part in literary activity. That's
How
why
many poems have been written by you?
published poems near about 100, my lord.
On what topics? On what subjects?
On
diverse
on
topics?
diverse topics on campus, like on
Contemporary
humanitarian problems,
social problems.
contemporary social problem regarding witches and rape of innocent girls.
Anyhow, 7. You come next.
In 7, there are 15 public universities governed by the Odisha University Act 1989, and the state, neither the state government nor the universities have taken any step to fill up more than 1,300 posts lying against sanction 200 posts. They are heavily the universities are constant to rely on guest faculty. Therefore,
Guest faculty, not the permanent faculty.
not permanent, my lord. And more than 1,300 posts when the petition was filed. Now it has come to my knowledge that more than 1,400 posts are lying vacant. For example, at Ravenshaw University of Cuttack, 161 vacancies. In Utkal University, 136 vacancies. In some universities, since their constitution or establishment, no recruitment has been made. I may come to para 4. Para 4.1, my lord. Out of 2006 sanction posts, 1,332 teaching posts.
What is the use of writing in a shorter manner? Name of the university, Utkal.
Yes, my lord.
Name of the university, Ramansa.
Yes, my lord. Page
Will
4.
you not say the full name?
Yes, yes.
The name of the university, MSCP. How do I know MSCB? How do I know Behrampur? How do I know GM? How do I know Fakir Mohan?
Yes, my lord. I met.
What is the full name? It's a college, it's a university, deemed university, what? Very conservative. Rajendra. I do not know what that Rajendra means. Then Dharnighar. Look,
You have stated in Vikramdev University, out of 111 sanction posts, all posts are.
All posts are. Vikramdev University.
This he has offended. This and the way of describing the university. Look at it. Absolutely, I would say, casual way of this.
The proceeding clause, yes.
No, no, he has stated, but what is this?
Understood.
My lord, that should take care. Let them file an instruction. I will take care of all these things.
Some may be a college affiliated with the university.
No,
some
my
may
lord,
be
all are
in the university.
My
Some may be an university itself.
lord, no. I made it clear that all are public universities governed by Odisha University Act 1989, my lord.
True. So there are, I do not know, because I've come from a place where there are many deemed universities
No,
which
my-
are given the status of the university.
my
There are
lord,
many autonomous universities, autonomous.
all are public,
Is-
all are public universities.
Structure or a stature has been given.
No, my lord, kindly see part.
This
Annexure-
Ravinsha College.
Annexure 1.
Is it a university
Yes, university, my lord.
under?
Under,
It's a university.
kindly see Annexure
Let
1.
me
my lord.
understand. It is a university. When a degree is granted by whom?
By the university, my lord.
University itself in its name,
In its-
perpetual succession.
Yes, perpetual succession, my lord. Kindly You peruse Annexure 1, my lord. All universities are listed. Annexure 1, my lord. Page 12.
স্ক্রিনটা খারাপ হয়ে যাবে স্ক্রিন
Yes. Yes, what do you say?
Well, the Odisha Universities Act 1989 was amended in 2020. Earlier, the universities used to conduct their own recruitment. In 2020 amendment, power was conferred with the Public Service Commission to conduct the advertisement in respect of all universities. Then two successive advertisements were also made. Pursuant to one advertisement, appointments were made. But during the pendency of those advertisements, the virus of the statute was challenged on the ground that the universities lose their independency if there is state intervention in the recruitment process. Now that matter was subsequently carried to the Supreme Court. During pendency of that, after the change of the government, the new government, they came up with the amendment. The 2020 amendment was withdrawn. Then again, the power has been conferred to the respective universities to conduct the recruitment. So these, I'll bring all those.
The position that you.
No, my lord, it was done in the new amendment came on 14th.
So whatever be the reasons,
Yes, sir.
if not what they say that previously this power was given to the respective universities to fill up their posts.
Yes.
Make a recruitment. Now, after this act, this power was
Giving
I
back
would
to
say
the
snatched or robbed by the state from the universities and wanted exercise. While it was challenged, now the virus has been appealed or
But during pendency of that, the state has amended its.
the single bench here failed or declared ultra
Declared.
declared. So
No,
now that is
I'm sorry, my lord.
No, no, no.
The Honorable Court declared it as intra-virus, was carried to the Supreme Court.
So is in trouble. Now it is battle was pending in the Supreme Court.
My lord,
Now in the meantime, they have brought the amendments. And now again the power is reversed to the university. So it's a university who will take care of.
No,
But the
my-
state has to do.
my lord, I want to make two summations. That on 14th April, 17th April 2025, the amendment was brought, giving back power to the university. On the landed Advocate General appeared in the Supreme Court on 7th May, and the Supreme Court allowed the government of state of Odisha and the universities to conduct
That is
appointment.
the university, not the state.
University, yes, my lord.
So
I made also universities parties, my lord.
you then all let the notices be given to all. It will make more clumsy.
But actually the universities function under the direction of the state government.
For the purpose of recruitment, this amendment is there, which confers power upon the universities to do. Then what under the direction? It is by virtue of the power given by in the statute, they will do it.
But they are not doing it, my
So
lord.
that is a different issue.
That's why
And when that amendment has come.
17th April 2025,
So what is the timeline? Now we are in September.
5 months elapsed.
So what do you think? Are you not aware of the snail pace in which all these authorities they move?
All I submit,
What do you think? One overnight, something will be done. There are procedures to be followed.
my lord, the
Don't come. You are a public spirited person, but do not come for such purposes that every PIL is to be entertained in this way. They have to be given something, a buffer time, something that the breathing time they should be given to do it. And if it is in April or a March amendment,
Amendment in April.
April 2025.
20.
So now there's a May, June, July, August, September. These are 5 months have not expired. There are many preparations which has to be done. Advertisements have to be done. Article 14, Article 16, those have to be followed.
But the recruitment process has not been initiated, my lord. That's why I'm
Can you expect? Can you expect?
my lord, after the amendment, they should have.
Even in the April, sir, there should be some breathing time which should be given to the universities to ponder upon. It does not mean I can appreciate it that they are sitting tight over the matter as you projected here for a pretty long time, and they are adopting a particular I think the procedure which is not provided. I can understand. That is what you projected. But now after knowing this, well, if you want your PIL to be just remain in I have many words in my mind. I'm just thinking whether to use it or not to use it.
My lord, I am coming with a public purpose, but if
What is the, sir, this is the fact which discerns, and you have affirmed the affidavit when this petition, when it is filed?
on 6th August.
So, April, May, June, July, August, not even the 3 months or 3.5 months.
After 4 months, my lord, I came.
Whatever, the 4 months, what do you pick? Are you not taking 2 weeks time to draft the petition?
Yes, my lord.
So, if you can take 2 months time, considering there is a gross violation of the principle of natural justice or a constitutional right, then what do you expect from them? You understand? EIL is not used in this. I have been watching here that EIL is filed in
My lord,
such
I
a
encourage my
casual manner that everything is PR.
My lord, I thought that if the honorable court just intervenes,
No,
it
you
will
just
expedite the process.
understand you are simply wanting to accelerate
Expedite.
using the High Court as a medium, as a tool.
Not useful, my lord, because
That's true. You are using the High Court as a weapon in the guise of a peer. It should be something.
then I may be permitted to.
No, then take a decision, but this cannot be done in this way. PIL, no. They have got now bring those facts.
I'll
decide.
Well,
Yeah, exactly. And issue notice on all the universities whom he has made up. He has not. He has made all the universities. So from
Number 8.
My lord, I may be telling that. Requisites, yes, my lord, I will win time.
right.
3 days.
Item number 8.
I'm seeking Lord's permission to appear online, Lord. So sorry, my Lord. Being an outstation counsel, my Lord, I'm not in a position to appear physically. So, my Lord, do pardon me for this.
What is this matter? Why is the question? It's the legitimate. Oh. Yes.
Lord, my Lord's voice is not audible. Probably, my Lord, it has been lowered down.
Yes. What is you are appearing for whom? Mining Corporation?
Yes, ma'am. In fact, this requisition is premature. After filing of the requisition, without inquiring with the authorities as to what steps have been taken on his representation, he has approached this honorable court. I have stated in my instruction that authorities are in session of the matter and the representation filed by the person is under consideration. By a committee has been formed. Last line, madam. Paragraph 4, madam.
Have they approached the authority to know that what has happened?
No,
Huh? What the RIT rule says something here?
My lord, we approached the authority, my lord, on 25th of June 2025.
Where is your
198, my lord. Annexure 7.
he's under consideration. After filing.
Therefore, my lord, we came after waiting for 1 month, more than 1 month, my lord, we came to your lordship. So if the committee has been constituted, my lord, to resolve the dispute, my lord, I would be happy, my lord, to go with the committee. But in fact, they should first should have intimated me, my lord, that I'm so sorry.
yes.
would like to indicate any date expeditiously in 4 weeks.
No, sir.
Sometimes, my lord, the government sits over the matter and
They have.
Last occasion we seek for instruction. I don't receive the same. It is a policy decision of the government of India to accumulate the different sources for better service. So I need for more time to get instruction. Let's may keep it to after vacation.
1 week after vacation.
Item 11.
What is for the 5?
Tender, which is adopted by the capital region urban transport matter.
Who is appearing for the opposite party number 5?
Senior is appearing and I have served a copy on last occasion also. Yes, so.
What is your ground that they should not be awarded that marks?
My first occasion it has been published on 10/4/2025. Thereafter it has been cancelled. Thereafter the clause has been inserted in the said tender call notice to accommodate this society to participate in those who have registered on the Society Registration Act. They have to participate in the said tender, and the opposite party number 5 has participated in the tender, and also he is selected in the technical bid, though he is not qualified in as per the eligible criteria, and marks have been awarded to him.
What is the eligibility criteria?
Your Lordship may see page 83 of the tender document, First 81, qualification, there it is been stated. And thereafter,
What is this qualification?
qualifications, legal entity. The bidder should be a company registered under the Indian Company Act 1956/2013 or LLP, firm under LLP Act 2008, society or partnership firm.
Correct.
But thereafter, experience of the bidder.
Yes.
That is, it is considered bidder should have at least 3 years experience in providing manpower service with a minimum of 3 consecutive years of experience in providing at least 100 technical and professional manpower to any state government department, state public sector undertakings, or any other central state government entity in Odisha. Thereafter, in Lordship may see page 83, there how the marks will be given, that has been mentioned.
Okay.
In TQ4, my lord, it has been stated that the bidder experience of executing transport sector project 1, each project shall carry 10 marks and 15 marks is maximum.
Correct.
As per my submission is that the petition, the opposite party number 5 has not completed 2 words, my lord, and 15 marks has been awarded, my lord. He has only transport sector 1 tender he has completed, and another which has been verification has been sent for, that is relating to maintenance of the bus stand, and that is not relating to any technical portion, my lord. And apart from that, the petitioner is a society. I have
So society is eligible.
eligible, man. But the bylaws doesn't disclose that he can do this, the participate in the tender in the providing manpower, man. And as per the Societies Act, your lordship see, the Societies Act, your lordship may see, it speaks 1 capital A, my lord. Societies. Let's 6, madam. Let's 6 of that book. 1 capital A, madam. Societies formed by memorandum of association and registration. Any 7 or more persons associated for any literary, scientific, or charitable purpose, or for any such purpose as is described in section 20 of the Act, may be subscribing their names of a memorandum of association and filling the same with the register of societies for themselves into a society under this Act, my lord. And section 20, my lord, your lordship may see. It's page 13.
May I read, ma'am? So, to what society the act apply? The following societies may be registered under this act: charitable societies, the military orphan funds and societies established at the several presidencies of India, society established for the promotion of science, literature, or the fine arts for instruction, the diffusion of useful knowledge, the diffusion of political education, the foundation or maintenance of libraries or reading rooms for general use among the members, or open to the public or public museum and galleries of painting and otherwise art collection and natural history, mechanical, philosophical.
This is only for the purpose of bringing the society within the purview of this act.
Minor.
It does not mean that societies which do not come under the purview of the act.
Yes, ma'am. This society is registered under the Society Registration Act, my lord. Your lordship, I have annexed the bylaw as well as the at page 4, at page 111, my lord. And enter their aims and objectives and memorandum of association I have filed, my lord. Where nowhere it has been stated that they will do this type of work, my lord, and participate in the tender. And society is formed for benevolent purpose, my lord.
What is the meaning of the word any other particular purpose or purposes? So apart from the same, it can also be for any other purpose.
My lord, it should be mentioned in their bylaws, my lord. It is not mentioned anywhere.
That is the internal matter.
That's
the internal matter amongst the members of the society.
Well, they have given it along with the tender documents.
If they were already working somewhere else, then what is the difficulty?
They have worked in several places. And also, just 3 days before, I came to know that they have a criminal case, and also for that reason, some tenders has been cancelled. And I want to bring
What criminal case? Criminal case against the society?
Yes, madam.
Lost or
it lost someone at Balasar, and for that reason, a tender has been cancelled. On April 2025, madam. It has been registered 3/4/2025, madam.
And when they participated in the tender?
Thereafter.
The tender was called when?
My tender was called on
June,
madam. 18/6/2025.
Was there any notice given to them or pursuant to the?
I have no knowledge, but in month of August, a tender has been. They have participated in a tender at Similpad Wildlife Division, madam. That has been cancelled. And I want to bring those things to record by way of affidavit, madam.
Is there any clause which permits them or which renders them ineligible?
No, madam. In the tender, that is not there. Only if there is any conviction, that is there, madam.
So,
and
mere lodging an FIR does not mean a conviction.
No, madam. I am not.
So then, how it is relevant?
But there is other clauses are there.
Well,
if there
maybe the other
integrity is doubtful, then
other authorities might
yes,
have. So they might. That is
if
the
their
independent.
doubtful, then
That's the independent cause of action. They will take care of that.
for that reason, other tenders has been cancelled. That come to my knowledge.
How it is relevant? This is what you say.
Sir, your lordship already dealt with this matter. If your lordship kind of look at your lordship judgment, same questions raised by another tenderer, and your lordship was dealt with threadbare. If your lordship kind of look at this question, paragraph 2, Ballard, if your lordship looks at the memorandum of article of association at the time of registration of society is annexed to the writ petition where the primary main object and ancillary objects are clearly and precisely incorporated therein. So the main object relates to providing the health, care, facility, education, agriculture, animal husbandry, so and so. The ancillary object which are incidental to the main object also provides that they may accept the monetary donation, may also do other lawful things as may be incidental or conducive to the attainment of the object above objects. Clause F under the broad heading objective incidents to the main objectives gives power to the society to vary the measure and auxiliary objectives if need to so warranted. All the income and earning will be solely utilized and applied toward the promotion of the initial object. Therefore, there is no pleading to the effect that the member of the society cannot take an uniform decision for rendering those services for which the tender was invalid. Rather, it implies corroborates the functioning of the organization when a plea is taken that the turnover of the society is providing such services higher than the turnover of the petitioner. The moment the society is actively engaged in providing such service in pursuit of an income of augmenting the income to be utilized for the main major and essential objective, we do not find any justification in the part of the petitioner to create an obstacle in the tender process. Section 12 of Society Registration Act, so far as the Odisha amendment is concerned, postulates that it appears to the governing body or any society registered in the Act which has been established for any particular purpose or purposes. In the event it is so advised, such governing body can alter, extend, or abridge such purpose to and for the purpose for which meaning of this Act, provided the governing body must submit the proposition to the member of the society in the printed report and may convene a social meeting.
Special meeting.
Consideration thereof according to the regulation of the society, and the said provision is quoted below. 12 has been quoted by. Para 5, if you receive terms, the reading of the aforesaid said provision doesn't inculcate the sense of the society cannot alter the purpose for which it was so initially constituted. The governing body, with the concurrence of the member, may alter, extend, abridge any such purposes. Since the society is actively involved in providing such service in different hospitals, which can be reasonably inferred from the turnover disclosed by them, we do not find there is any substantial contents of the petition that they cannot do a thing which the article of association doesn't provide. We do not find any absolute fetter or prohibition created in the statute of the society registered under the said act, or to forbear from doing a thing not contemplated or incorporated in the article of the association of memorandum. Rather, Section 12 of the Society Registration Act bestowed power upon the governing body, alter, extend, abridge of any purpose object to the fulfillment of the said condition mentioned there. Now, then again, you also dealt with regarding the FIR he is referring to. So, for the non-disclosure of FIR is concerned, we find from the date of lodging of FIR, the submission of it is in the close proximity of time, but do not find mere lodging of an FIR without any intimation or communication in this regard should stand a disqualification at the time of submission of the hearing. Had the person consciously suppressed the fact he disclosed the false information, the position would have been different. There is no material forthcoming from the factor of the lodging the affair was communicated to the opposite part number 6. Therefore, you do not find that it would be invalid disqualification. A person approaching the court must come with full disclosure of legally enforceable right and the material which will have some nexus of bearing the conjunction of the statutory provision, and not on mere submission or conjecture. Since the petitioner has miserably failed to provide any corroborative evidence support the first stand, the writ petition being vexatious and frivolous is to be dismissed. Accordingly, writ petition dismissed the cost of legal housing. But here the technical bit, the number was same. Technical bit, the marks were the same. Turnover was taken into consideration by the specific clause. If everything is same, the higher turnover.
And this was in relation to which tender? The same tender or what?
No, other tender.
Other tender.
They have not completed 2 hours. Marks has been awarded, 15 marks has been awarded. Relating to the amendment, there is no such document to show that amendment has been taken by the society.
That is not, that is an internal matter.
But they have to submit for the authority.
Nothing. That's an internal matter. It is a society who is permitted to participate. He is admittedly a society participated.
Yes.
That's why this observation was made.
But there is no document before the tender committee.
That I understand that awarding of 15 marks is a subject matter of challenge.
Yes.
So according to you, what are the materials which they submitted?
They have submitted, your lordship may see the technical evaluation committee report. They have submitted one manpower supply, Orissa State Road Transport Corporation, serial number 2, providing a manpower, block supervision, assistant manager, information, management information, driver, and supporting document on 24/11/2020. Another has been stated that at 8/12/2023, which is not correct, my lord. The inquiry has been made by the tender committee, and a letter has been issued to the Road Transport Corporation, Bhubaneswar, relating to the work at Balangir, not at Bhubaneswar.
So what? It does not restrict.
No,
Bhubaneswar.
madam. These two works they have stated, that is not the tender properly there.
What?
That is not the work they have done.
No, no,
at
where is the
Balangir.
evidence that they have not done
Madam,
the work?
I have.
There is no
One of the
evidence which
appears
is
they have not
forthcoming.
supplied the entire documents.
That's
and the
why
part
we
of-
say the mere on surmise and conjectures, one cannot go and achieve the purpose. This is merely on a surmise and conjecture.
That if the entire tender document will be called for, then it will be.
So why should we
But
be
they have not
used as
only this much.
why should be used as a medium for gathering an evidence for you?
I know, I go down for people, only RTI, they have supplied this much only.
That's all. If the thing comes, if nothing comes, then you can't.
Because we have seen those documents, those are.
And you have seen the last portion of the order.
Yes, madam.
The last portion.
That will be doubled.
Last portion of this order.
I have placed my case before your lordship.
No,
It is your
my
lordship, because I have not wasted the time of this court too much.
Mr. Biswar,
My
my lord is asking me to write. So
It may be exonerated
must-
for me.
No.
Because I am not.
I will double the. Last one.
Fees भी नहीं ना
It is not.
ସାରଙ୍କର ସେତିକି ଫିସ୍ ତାଙ୍କର କଣ ଗଲେ ଚଳିବ ମୋର ଫିସ୍ ସେତିକି
The ସମସ୍ତଙ୍କ fees ମିଶେଇ So it will be double.
I have not,
Choice is yours.
I will pray before lordship, because lordship is rejecting my petition, then no cost will be incurred. Only that much I can say.
And rest part? Rest part? Rest of the part?
As for your lordship, I cannot say anything about that, my lord.
So you knew the result.
Because that is I dictated, so I
No,
have already
I-
expressed my
just-
mind, so I just
just
request
now
my
I go-
brother this time.
Just
You
now
write.
I have gone through this order when my lord and senior has handed over to me.
Hey. Sorry. Yes.
Item 12.
Your Lordship, I appear in item 12. Forgive me for my absence from the court physically. My Lord, this is a tender matter in which a tender was floated by the DFO for the supply of 2 AI towers in the Debrigarh Wildlife Sanctuary. Now, what has happened, my Lord, is a tender floated in October last year. I was awarded the tender as the L1 bidder. And then subsequently, they constitute a price justification committee, saying that the price I offered was not adjustable. And in that price justification committee, they include another company.
Can't hear you very precisely. Can you come closer?
Is it better right
Yes.
now, my lords?
Yes. Yes.
I apologize. My lords, so a tender floated in October 2024 for the supply of 2 AI towers at the wildlife sanctuary. Now, pursuant to that, I apply. I am adjudged L1 and a work order is issued to me. My price quoted is 92 lakhs 74,000. Now, subsequent to the allocation of the work order, I perform part of the tasks assigned. Later on, the DFO says that we have found that your price is not justified. After allotting the work order, he constitutes a price justification committee. And in that
what you did? What you said? We constituted or what? What you said?
Opposite parties constituted a price justification committee, my lords.
Okay.
To go into the price.
Okay.
And in that committee, they include the representatives of another company, OP3, which is a competitor entity. That price justification committee comes out with a report in February this year saying that my tender should be cancelled and this whole thing should be retendered. And in July 2000 of this year, the opposite party number 3, which is my competitor entity, is allotted the same tender for the same price. If your lordships would just see a few pages, my lords. If I could take my lords through...
it has really gone over. What he really want to say? Are you aware? Okay. Who is his representative? Any junior? Who is the advocate on record?
Your lordships, if the audio is unclear, then if your lordships could have it on Friday or Thursday, then I'll come physically before my lords, since there's an audio problem, my lords.
Because whatever you have submitted, it has really gone. We could not make a head and tail from there, because there were some audio, some voice, some words that did not come to us.
So would your lordships have it, because there's an audio problem, I think there's a problem with the VC link, because I'm in Delhi today, my lords, unfortunately, and I think there's some interference. So would your lordships have it tomorrow, if it's possible, my lords? It's a short matter.
Come tomorrow.
Very well, my lords.
What is your instruction? You have to take instruction. Today itself, take an instruction.
Item 13.
Concerning that tanker trucks.
Oh, I have already started a dictation. I think it will be finished by today.
Once your lordship is to pass.
No, just wait. Spill over for 1-2 days. I will be sending to my brother just to look at it. I have all the reasons.
The only thing is that in my packet, I have sought a copy of Mr. Srinivas appearing for SPCL. SPCL is contingent upon your lordship's order. We passed in the other part.
We keep on full.
That's the point.
Yes.
Can I
Just keep
Keep in a hold.
Just day after tomorrow, we are keeping this matter.
Right.
We'll see to.
and filing my document?
Yes.
Taken on paper.
Item 14.
Great. Public interest litigation. Here, point Miller. Now the state government department of housing and urban department to notification that by the state. The inviting objection with regards to declaration of NSC.
What is this NSC?
Notified Area Council.
Okay.
Here, Miller, document is the best. They confer the clause 2, Article 243 Pure Constitution of India, clause 2, Section 4 of the Odisha Municipality. Here, Miller, the state government notified all block headquarters with proposed NSC except the present. The present one is not block headquarters, Miller. I am on villages of the block headquarters. Just a moment. Page 7, paragraph 6. I have quoted Miller. Article 2.
No, first you tell me 16. They have regarding the population, the density of the population, revenue generation, percentage of employment in non-agricultural activities, and economic importance of the revenue villages.
Yes.
Specifies those area as Chitroda, transitional area.
Yes.
What does it mean?
Transitional area means, Miller, page 7, paragraph 6, I mentioned, Miller, the quoted Miller, in
surplus 2. The article, in this article, the transitional area. A smaller urban area.
The transitional area.
Area means below.
What does it mean? Page?
Page 7 below. Paragraph 6 below.
That is 243Q.
243Q, surplus 2 lossy.
Mr. Counsel, what is transitional?
Transitional area means a smaller urban area or a larger urban
It
area.
it says transition from a rural area to an urban area.
Urban area.
So
Here, Miller, I am on approximation. The generation of revenue, percentage of employment, then employment in non-agricultural activities and economic importance of the revenue villages. Just a moment. The notification that is page 16, the villages, the 8 villages having no revenue generation. Here, Miller, the Moroda is the block headquarter. The industry.
So it is a discretion which is given to the governor, taking into account all these factors,
yes,
which they have also I think clearly stated in the notification. So it is really a decision to be taken by them.
There is a lordship this notification of the objection. We have filed objection annex 3.
Where is a provision for an objection?
Objection, my lord.
I just wanted, there must be a right to object. Where is the power?
This one, this notification.
Which one?
Last paragraph.
Page 16.
Page 16.
Page 16, last paragraph.
Objections and suggestions in writing are invited from all persons likely to be affected within a period of 30 days.
Correct. Through the district magistrate. So what happened?
We have already filed objection. Our prayer.
So they let them take an objection, decide an objection.
Direct the opposite party.
And this is PIL.
This is the PIL.
Tell me the PIL is maintainable for this mandamus. Directing them to consider the objection. Tell us. Now tell me, now I am strict. Tell me the PIL is maintainable.
Petitioners are apprehending if they are not taken into.
Sir, I am asking you, show me that PIL is maintainable in this regard.
No.
How can it be? Public interest litigation not considering the objection, that is for consideration of the objection. They have not taken a final decision of declaring.
So that should have been the
Yeah. So you are still under the process of considering all these things. How?
in Annex 3 also, you have admitted that it is draft notification.
Yes.
So how can a PIL rise of this nature? Public interest litigation.
On apprehension.
On apprehension, my lord.
So does it lie?
No.
Then we are dismissing with cost. No, don't withdraw. Don't withdraw. No decision has not been taken. Nothing has happened. You wanted your gram panchayat or whatever to be also included. Is it?
So my prayer is to headquarters to be declared.
Oh, that's true. And the PIL. No, brother. It should be dismissed with cause. Give me the constitution. And where is the Odisha Municipal Act? No, sir. The instant public interest litigation is I am groomed in a system where cost should not be less than 6.
I'm 15.
Muruda or Morada?
That shows Muruda.
Successful?
Lowest bidder.
Lowest bidder. Okay.
Lowest bidder.
Okay.
Instead of calling me for signing agreement, no, but they floated, the opposite party floated the second tender.
Without cancelling the first.
Cancelling the first.
So they cancelled it.
Cancelled it.
What was the reason for cancellation?
In order to know the reasons, I made an application under RTI Act to supply me information. What prompted them? What are the reasons for cancellation of first tender? That information was not supplied to me. Apart from filing that application, I also made an application before the opposite party number 3, that is collector, under annexure 4. 4, that is at page 23, madam.
Yes.
23. Your lordship got it.
Yes.
Prayer portion I am reading, madam. Here suitable steps kindly be taken to release the confirmation letter against the above. Work soon.
So is a technical reason they have cited. They have cited a technical reason. For a technical reason, they are cancelling it.
Madam.
So you have just given it those documents.
I have also annexed my state.
Oh, state has given.
Corrigenda, my lord, that is at page 26.
Yes.
26. Due to technical verification and proper scrutiny of application, first tender was cancelled. That is not the valid reason.
What you have challenged here? What you have challenged here? You have challenged the second notice.
Second notice.
Without challenging the order of cancellation of the first tender. If that order remains and uninterfered with, then there is no tender. They can float us for subsequent tender. You have not challenged that order of cancellation of first tender.
My lord, I was lowest bidder so far as the first.
Does it mean, suppose if you are a successful bidder, does it create any vested right into you for awarding the contract? If it does not vest any right, then what remains? I'm stuck with Supreme Court judgment. It says no vested right.
Last date for receipt of the bid today.
But you have not challenged the cancellation order. You are aware that they have cancelled it. If you do not challenge the cancellation order, then it is there binding. You have accepted that. If they have cancelled the first tender, they can float the second tender. Where is the difficulty?
I may be permitted to participate in the second tender.
I do not know the last date.
Last date, today is the last date.
Go and participate. Who prevents you? If today is the last date, you can participate. There is no difficulty.
Tomorrow is fixed for the opening of the tender, my lord.
If today is the last date for receiving the tender, so how can you prevent him?
Submit.
So let him submit. Go and submit. Should we record the reason?
Why will it? No.
Give.
Memo, you file memo.
Permitted to withdraw.
File it. You ought to have challenged the cancellation order. Not challenge. Yes.
Well,
Call the name.
item number 17.
Yes.
17.
They have as well specifically how the public main entrance road is being permanently blocked for 12-15 days for performance or dance, orchestra, music on the occasion of one student, and then Durga Puja, and again to the whim and emotion of those group of people who hold Jatra, and that is permanently. Can have a look for a moment at page 20. How they have used huge, they have constructed permanent huge structure using heavy iron beams. They don't allow people, most populous village of Bhubaneswar under Bhubaneswar Municipal Corporation, that is more than 10,000, and the big colony is the other side, adjacent to Gargar High School, 100 years old school.
What is this, madam, going on? If it is a public road, can you make any construction for such purposes? You can take it on the adjacent of that, but the access has to be.
Man, there is a very ideal place, more than 1 acre of land they have kept under occupation by putting compound wall, by putting fixing gate, and when they were advised by the villagers, the elderly people, that why don't you go there and just on the side, on the way. I have a kind of look at that picture. Photograph, I think. Well, they can, but they use that for the commercial purpose, like renting it out for marriage function, renting out for marriage function, for trade ceremony, for
What are you doing on a main road?
and taking money. We don't mind. You take money, but you hold this function there only.
Why on the main road you have blocked the access? That is a road. How can you make a construction? What instruction? This is not acceptable.
But I wrote to the
Which page you are looking at the photographs?
This
Oh.
20, annexure 4.
Annexure A1. This is the road.
4.
well, page 23 kind level road and this structure, huge
I
structure.
am
kind
at
level.
page 22.
With these photographs, IAC was requested with a letter. Then Commissioner of Police, I personally met the Commissioner of Police on 25th at 1 o'clock, requested him with a copy of the letter already sent to him. He promised that he will pass appropriate order.
No, this is adjacent to the road, or it is, but because you are saying on the road.
While going from
Sir,
this,
22
my lord will kind
is-
see the road and the entrance village is here, where the structure is built.
This is on the road.
Yes, on the road.
Page 23.
Yes,
Page 23.
on the road.
Sir, what is this, madam?
There is something I understand.
What you have done? And this is a motorable road.
Anarchy, total anarchy of this group of people.
Page 23.
Your Lordship, I've seen
Is it not on road? Is it not on road?
This is on road.
And if you go back 22, the allotted place is there, I think. Page 22 is allotted plot,
Yes, Your Lordship.
which shows that it is a Vivaha Mandapa.
And what is this 24? That newsletter, what it says?
Well, 24.
Yeah, I can't read. What is the thing which is written?
Well, this is a news publication. This is 24 is the news publication. How
what,
For what?
what do you say about
Yeah,
22,
yeah.
page 22? That is what you are indicating, that they have allotted plot with boundary wall, but they are using it for some other purpose, not for this
Yes,
purpose.
madam. Page 22 is not allotted, it's forcibly occupied for decades.
Maybe, but under their
But there is
possession.
one signboard. There is one signboard. What is this signboard?
Bright Star Vivah Mandap.
The club's name, that this is Bright Star Vivah Mandap. Bright Star Vivah Mandap, which is rented out permanently.
Bright Star.
And this is this construction. This is the construction on what?
Pardon, madam?
This is the construction on what? Is a separate land or a road?
Separate land, just can you have a
Oh, adjacent.
the other side of the road. Other side of the road.
It is in their, it is in their possession.
Their position.
They have put boundary wall.
Yes.
And
And fixed a gate and using it for commercial purposes.
Commercial.
There we advise them, people advise them, elderly people, that look here. Because that is bad.
Who are doing mostly? Who are doing all these things?
this is a club. Bright
Who
Star
is
is a
doing?
club. Bright Star is a club.
These Bright Star Club people and also other group, Bright Star Club people, you use it for Jatra and Ganesh Puja. The other group, they occupy the road and construct structures, similar structure for Durga Puja. They are now making arrangements within two.
This is temporary structure.
Sir?
Page 23 is temporary structure.
Page 23 for 10, 12 days. I am obliged. I am obliged.
For
Page
the
23
purpose of
temporary structure for 10, 12 days.
for 10, 12 days.
Yes. They don't allow.
For the purpose of puja.
Pardon, madam?
For the purpose of puja.
23 is a temporary.
Yes. 23.
Performance
That
of
is
Ganesh Puja, it is over. I have given the photogram and I can leave it, even this. On 1st September, the structure is still there. 1st September, Ganesh Puja is over on 28th. 1st September, the structure is still there. There 2-3 days after.
till immersion takes 10 days.
No, beyond immersion, 2-3 days they still continue because immersion was probably on.
Yes, you take steps. This can't be. You take instruction. We are keeping this matter on immediately after the opening on 8th. We are keeping this matter on. This cannot be done. There may be temporary, the arrangements that can be done, but for a period of 1 day, 2 day, or 5 days, whatever. But you can't keep it perennial for all time to come and then obstruct the flow of the this one. Or you do it where you should not put any kind of an obstruction to the commuters.
Communication of the public. But the local
Just,
IS
tender was floated for mining operations. It was floated by Orissa Mining Corporation. Work was going on below. There was a huge landslide in the mining area. Huge landslide.
Must be because of you.
Not because of me. Nothing because of me. Admittedly, a case of force majeure. Admitted. I informed them about the force majeure event happening.
Was it an act of God?
Yes, it is defined. Under the contract itself, it says this landslide is a force majeure event. And I intimate them, as per the clause, once you intimate, within 6 months, if there is no resolution, then the party becomes entitled to terminate. I become entitled to terminate. OMC never responds. I keep writing letters. 8 months after they write, 9 months later. I'm sorry, 9 months.
OMC has appeared.
I'm sorry.
OMC. The first time it has come.
Yes, but then I become entitled to terminate. I give the termination notice. Termination notice has come into effect. After that, termination notice came into effect in January 2025. In September 2025, an order of forfeiture of my security deposit and debarment has been passed. After I become entitled. Now, if I may kindly trouble your lordship with the pages,
How can it be? Have they given any opportunity
Yes.
before the department?
Yes, they have given that opportunity, Millets.
Hmm.
They gave a show cause notice way back on Millets.
1905.
19/5/25, they gave me a show cause notice.
Yes.
2/6/25, I gave a detailed, exhaustive reply, which is in sync with what I have stated earlier in all my letters.
Issue notice on that to Odisha Mining Corporation. Immediately after vacation.
Yes.
Why Kotak Bank?
What if you do that?
Millets, they have
Why Kotak Bank?
Why?
Kotak Bank, Millets, because my
Your bank guarantee is invoked.
my bank guarantee is
Has
being
been invoked.
Millets, that cannot be. I'll demonstrate, Millets. Millets, let them not.
You know the law on bank guarantee.
Millets, here is a question.
The interference by the court in relation to a bank guarantee is known to you.
Yes. But Millets, what is happening is this is beyond that. contract.
Whatever we have to hear them and then pass the order. Bank guarantee we can't. The department is there immediately staying. The department will be so that's why giving you a short notice.
I can demonstrate it. I'll show the pages. Your lordship.
Just
Absolutely.
I just immediately on 8th keep it. Keep it on it. We'll see to it.
Let's let them notice in the IA also.
Yes.
Both, sir. Both.
So take notice. Yes.
Item 19.
Okay.
In the meantime, Millets are able to collect some office orders relating to entry taxes. It was given by the commissioner. Before the tribunal, during the pendency of the tribunal, commissioner says that there's no fruit grounds. The lordship would kindly turn to Millets.
If he has granted, there were two others. Has he granted to the others also?
Her predecessor, Millets, by a series, not have collected those a series of orders, not a series of office orders. I've given an additional affidavit. Lordship would kindly go through those orders. Additional affidavit. So if your lordship would just come to the Annex 14, Annex 7 at page 14. There was an amendment in the VAT Act that is dated with effect from 1/7/2017. The OVAT Act has been amended by the state government by OVAT amendment so and so.
He was satisfied with the mandatory pre-deposit.
No, your lordship may kindly come to paragraph 5.
That is what I'm reading.
And this Millets mandatory pre-deposit was there. Otherwise, my first appeal has not.
Understand. That is what I'm saying.
And my first appeal has been entertained after paragraph 5, paragraph 4 and 5. This has been applied, my lord, by Annexure 1.
No, that is the consistent view that the moment you have deposited, in that event, the rest of the amount will remain the same.
20% if I have deposited, then if your lordship would kindly turn to page 21. Another, my lord, Annexure 1 dated 23/7/2018. Again, my lord, the commissioner, he applies it to another group of persons. And the annexures, my lord, is there, my lord.
at page 23.
So this must not have been placed before
No, my lord.
the present incumbent.
My lord, I do admit, my lord, the present, even though the predecessor of the present incumbent, my lord, was the author of these office orders, my lord. Unfortunately, I could not produce these before the commissioner, my lord. But my humble contention, my lord, is even if I have not produced it, the commissioner, my lord, and her officers, they know about these office orders. They are conscious of these office orders.
They are supposed to.
They're supposed to know, but in that event, my lord, if the lordship would allow me, keeping the tenor of the order which he says that there's no good grounds, and in view of this, my lord, if the lordship would permit me to go back to the commissioner, produce all these documents before her, and say that her predecessor in re-examine the matter.
Let us consider this submission.
My humble contention before my learned friend.
If we still contest, then we will definitely.
So my humble submission, if I can go back to the commissioner.
Like these circulars are not binding, so it is not applicable. Let him start with this.
These are not circulars, Your Lordship. Your Lordship,
Whatever the office memorandum.
no, Your Lordship may kindly turn to page 12 of the additional affidavit. That is the office order. Page 12, Your Lordship. And the order for my learning here has shown, those are the orders have been passed in individual cases. In some cases, Your Lordship, where the second appeal is pending. In some cases, order the predecessor.
So why not the uniformity should be maintained? That is the hallmark of the judicial dispensation. That's the first principles of the judicial dispensation.
The office order,
And the certainty.
The office order is at page 12, annexure 6, which is binding to all, Your Lordship. Your Lordship.
2015.
Your
But
Lordship.
after also certain discussions, you were also.
Your Lordship. It is.
Why similar amendment was not carried?
Your Lordship. That I bowed on, Your Lordship knows.
Carry material with overtime.
Your Lordship.
Know very well.
Your Lordship.
Since
Why you say that only 12 is the binding order?
Your Lordship. Why
Binding order.
why 12, Your Lordship?
Not binding orders. What are you talking?
Not binding. 12 is
These
the.
are all the omnibus orders not concerning an individual.
12 is an official instruction which has been issued in what circumstances first appeal, second appeal.
You could not get it. My lord is impressing upon you that Commissioner has not taken up individual cases on merits.
Your Lordship.
It
Your
is
Lordship.
an omnibus order and very many orders.
No.
In respect of many dealers at one go in the same precinct. These individual cases have been considered.
No. Bunch of cases.
So,
A category says that if you say that it is not, I am not bringing it within this category, whatever. Everything has been done, then why this office order will not be followed?
you are concerned yourself in 2016.
Your Lordship, that was a problem.
Like 2016, you are there this side,
Your Lordship.
and you are party to those.
The commissioners meeting.
Commissioner.
I can understand the 11/3/2019 order, that is a different.
11.
Oh. No. He's really, this one, he's reiterating that particular principles which is there.
He's modifying his
Subsequent order, he's reiterating. And if it is a position, then how can he?
Your Lordship. All are different cases. All are different.
When you have not taken individual cases to disallow,
Your Lordship.
bunch of batch of matters you have taken at one go, considering that the second appeal is pending, that will be considered on merits. During that, you have already received the.
Your Lordship, only that is only on 19th for 2018. All the Now, before that, all second appeal stay revisions have been heard before different authorities. On that day, notification has been issued that only first appeal, once you deposit 20%, then the balance will be stayed. And all the second appeal stay revisions of cases will be heard by the commission. Only on 19th April 2018. And subsequently, your Lordship, the commission has passed this order and your Lordship. So, Your Lordship, I may be permitted to take instruction.
What instruction?
Just now I have received this copy.
Can you define?
Only so far as no, I cannot define. Your Lordship.
These are the ones,
Your Lordship.
even page 12, very clear.
Page 12, paragraph 4, Your Lordship. Only nowhere it has been stated that once you deposit 20%, the balance will be stayed.
Please, paragraph 3 has to be read.
Paragraph 3 is the first appeal, 77, Your Lordship. Your Lordship. So far as the second appeal is paragraph 12.
Principles have to be followed the same way.
You see, paragraph 1.
Your Lordship.
You read the paragraph 1.
Your Lordship.
What is your intention? Read aloud.
Your Lordship.
First sentence is very clear.
Paragraph 1 is VAT and CST, not ET. Not ET tax. This is so far as the amendment.
So CST principle is same, sir.
Where the dealer has already paid, OVAT and CST shall remain automatically stayed till disposal of the first.
You want a good judgment on this.
Your Lordship, kindly turn to page 14. Your Lordship, kindly turn to page 14 for a moment. Paragraph 3 of that page 14. OET is there, my lord.
No,
and first appeal, stroke second appeal.
But he's trying to
He's
trying to make a distinction that these are the orders which are passed in relation to certain appeals.
Your Lordship, those
It is not a general or
exactly
omnibus order which is to be followed.
Your Lordship.
The omnibus order can be seen from page 12.
Well, Your Lordship.
He says so that because there is no reference of this. Because in page 14, the section 1 are the where the state
from page 16.
Appreciate.
Is what I say. So
Continuous
this order, if this order is also, let us go by that. Even if it is not, there must be some standard of uniformity has to be. That's why
Right from 2018 to 19.
He has no answer to that. Uniformity.
And some parity has to be maintained. I can't be treated.
Your Lordship knows how. Your Lordship knows my difficulty. How can I answer? I can answer as an officer of the court, but obviously, Your Lordship wants I will take instruction.
No, what's it?
Your Lordship, let him deposit 20%.
Yes, already deposited.
I've already deposited at this time of first appeal.
No, first appeal.
First appeal.
Is there
Second appeal.
any condition for second appeal deposit?
No, my lord. If I've deposited 20% at the stage of first appeal, that's a pre-deposit term. I need not deposit anything for the second appeal.
What's
automatic?
Why this has come? Because 10% plus 10% later on. So total is 20%.
Total is 20%.
So at that around 0.5.
And so far the OVAT Act is concerned, they distributed it 10% at the first appeal stage, another 10% at the second appeal stage. But for OET, my lord, is 20% at the first appeal stage and no further. That was the gist and the purport of the orders of the commission.
Why they will deposit again? If the statute does not permit their order, why they have not deposit? Then how can you express?
For that reason, this paragraph 3 is there, not paragraph 4. What I on it? Paragraph D, the then commission has passed the order. Your Lordship, I bowed down. Page 14 is the order, Your Lordship.
So uniformity is limited. You can't change your decision.
The predecessor commissioner has passed that. So whether that
can we, our predecessor division bench has taken a view, can we consideration? We have to refer to a larger bench here, not by the.
Item 24.
May it please the lordship. My lord, your lordship had order dated 29/7/2024.
Very understood.
Asked to the grievance raised by the petitioner in the can be written that this order was passed on 29/7/2025. The prayer before your lordship was that instead of depositing the GST amount in regular GST number, and the petitioners wrongly deposited the previous GST. That is the wrong which has already been committed by the present petitioner. For that reason, my lord, that his 57 lakhs some odd amount was withheld before the rail because. And we have this opposite matter number 2.
In this case, last time the court has told me, I got a reply from the department. The court has told me filing a safe of affidavit. Within a day or two, I'll be filing this affidavit. I got the instruction from the department that we actually the time has been lapsed and we don't have any power to make any changes. Huh?
That means double tax system.
No, not safe. It's a GST and that it's a.
You will have two deposits.
No, we had only one.
Yes, account and instead of GST account.
It's
Now you are saying insisting
No,
to
no, no,
deposit GST.
no.
He is directed to deposit
Similar.
double account.
No, only once they have deposited in the wrong GST number. Lordship, like Lordship, Lordship, like the RC cancellation, we don't have any power. After getting the leave of the court, it can be given a direction. If the court can give a direction to the, then it can be done, Your Lordship. We don't have, as per rules and acts and rules, we don't have any power to do. It can be done when the GSTN 1 was there. He can go ahead and made a rectification in the due time. After that, they had a chance to file.
What is the instruction?
Your Lordship.
What is the instruction? That unless the court said that we can't open.
No, that's not the instruction. We don't have that. This is my contention that in safe of affidavit, you are told to file. I have
What he says.
So, Lordship, the statutory timeline prescribed under the GST law.
So he says that he cannot. There is no provision.
Your Lordship.
So the court's direction is the provision.
Yes.
That means so. This is a sheer. Then return the money to him. You can't. You cannot return the money. He has deposited the entire amount of tax, but it has gone into a TDS account instead of GST account. Now he says that please treat it as a GST account. Now you are putting all the spanner to it. I can't reopen it. It has gone there. And we cannot adjust it.
Sir, have you not gone to that compartment test? 250 pages. What Honorable Supreme Court in London said, you cannot retain that amount which is not due to you. Isn't it? Article 265 is staring at you. Is it due to you? Suppose something wrongly deposited. If suppose I deposit some amount in your account, if it is not due to you, will you not return it to the only because certain time is lapsed and you have spent that money, you will not return. Is it your appreciation of
you could have immediately returned it. Look, you have deposited in TDS, you can't go back. Take back. The money is rewarded. These are all electronic transfers. You would have reverted in the same accounts. But you retain the amount, you utilize the amount. Now you say, maybe in that account, we are not concerned, but we will not treat it as the compliance. You deposit in GST. Now suppose these deposits, so double taxation twice. Then what will happen to that amount which he has deposited? Look at the plight. You have to be very reasonable in this regard.
Mr. Gutsai, what do you say? You are representing union.
1 and 2 matters, but instructions will don't have the instructions.
No instruction. In every case, we don't have anything. They are helpless, so helpless.
We have written to, we have not received it.
I'll be filing in the shape of affidavit. Yes.
Otherwise, it will create problems otherwise.
In the meantime, I have filed an I, which is also Lordship's board. I, my lord, my 57 lakhs and some odd amount is due. It has to be paid by the RPN. So now, due to such type of wrong deposit, that he is not releasing my 57 lakhs, and I am unable to pay the labor and charges and other charges, and puja is added after 4 to 5 days. Dasara puja will be my lord, they will be observing our state of Orissa. So I am unable to pay the labor dues because 57 lakhs, my lord, is due upon the RBL. For that reason, I have filed an IA, my lord.
Why RBL is not paying?
Because, my lord, that I have, because due to the wrong deposit, my lord, of the GST amount, RBL is not paying the dues. What is it?
You say you can't reopen the portal. You've seen your instruction.
Before the puja, my lord, I have filed this IA for payment of the labor. 57 lakhs is the dues. So, my lord, I pray to pass the appropriate in my IA, my lord, that the amount.
Against railway where there is no grievance against the railway.
Railway, my lord, that RBN 57
interlocutory order. Interlocutory order is passed by the court made of the final relief.
Yes.
But what is your final relief? Something else.
My lord,
how can we pass a direction upon the railway because to make the payments?
That is right. My care is not there.
Similar circumstances, the Supreme Court has also said against the revenue recently. The clerical mistake, many cases. So this is one case where the Supreme Court has confirmed human error.
Who number of 9 my lord petitioners are equal. Last digit my lord.
Only you direct the GST
and movie mistake is no.
We have also decided 0.00.
In my case. At that point of time, I am searching those judgments.
All the number, 2 number of the GST and general GST and
TDS decided against him.
Yes.
Don't worry. Yes. Call the next one.
Item 25.
Moving on. Don't worry.
Fine. Problem.
Yes. Yes, sir. Item 25.
Quality service tax method, section 74 fee matters.
Item 26.
26 it is basically connect. This way. From BC my simulation.
Please, my lords. Am I audible, my lords?
Yes.
My lord, this is a consolidated show cause notice which has been issued without jurisdiction, and on 3 counts I am before my lords. The first is it is a consolidated show cause notice wherein the demand is from 2018-19 to 23-24. That my lords
We are
have
keeping this matter pending, I think. We are keeping this matter pending. That one show cause notice covering the multiple.
My lords have.
They have in prayer they have not made that.
What?
In prayer section they have
Yes, my
not-
lord.
Yeah.
What prayer section?
The repetition.
Uh,
Prayer they have not made that point.
what is the what is the what
There are multiple.
it should go in a prayer portion or it should be there in the writ petition. Prayer is the ultimate relief based upon those points. Have they pleaded that?
They have specifically challenged the show cause notice.
On multiple grounds.
Yes.
The prayer would be to quash.
Yes.
Have they taken in the petition?
In the petition there.
They have taken.
Yes, my lord. We have taken, my lord.
So on that ground itself, where is that order? Multiple? Give that. Yeah. Yes. Stay.
Highly obvious.
Yes. Next.
Item 27.
The matter was placed before the IPAT tribunal. The case was dismissed on the ground that defect has not been corrected.
Can we give me a hard copy?
Never been served. It was
Yes.
sent in the mail and the appellant skipped the mail. Therefore, the defect cannot be removed, and as a result, the IPAT dismissed the case.
Yes. So what more?
So I want the restoration of the case in IPAT.
Why? Why restored?
The notice was not served physically, it was sent in the mail, and the mail was skipped.
We are granting a final relief which you have claimed in the writ petition. We are granting a final relief. Yes.
The notice was issued.
No, you have not understood, sir. Don't go. Have you read your prayer? Have you seen your prayer?
Yes.
What is the prayer? When we say granting a final relief, you did not realize. What is your prayer in the writ petition? Page 6.
Admit the writ petition.
So we are admitting the writ petition, final relief and disposing of the writ petition.
If you admit the case.
By admitting the writ petition and disposing of. I have not come across in my career, both on that side or this side, this prayer. The writ petition, the final prayer is in the writ petition to admit the writ petition. Quashing, saying something. The final prayer is humbly prayed that the court may be issue, admit the writ petition. So we are.
The restoration is in the ITO.
Admit the writ petition you have written, writ application.
Wrongly. You have not prayed for drafting of wrongly. Wrongly. You have not made any prayer, only to admit.
And there is no gap in between one words with the another words. Look at it.
So that prayer was not correct. Yes, it is.
What to do, sir?
Yes, you have drafted.
Show it to the senior advocate.
So,
Now advise him what to do. Take it. Read the final relief, prayer. I do not know what to do.
And the amendment.
The casual way you are filing a petition, Kaleen. And you have a substantial year of practice, sir. Leave to amend. After perusal of the release claim.
Against the demand of the GST has approved the appellate authority that has been rejected. Similar. GST.
Tribunal. Case of a tribunal? Oh, Matarini. We have not disposed of. Subsequently, we have There is a subsequent order, sir, where we have kept all those matters pending before us. This was an earlier one. Our attention was not drawn. Give a subsequent one where the matters is.
just please.
Change it. Yes. We have kept other matters. It will be listed along with that matter. Yes.
The interim application there.
We have already said that you have deposited the amount, it will remain in state. That is what we said. But we have not disposed of the writ petition. We have kept the writ petition pending before.
Just keeping with.
Don't please. Return. You have that.
It's called the
Item 29.
May I please, your lordships? May I please, your lordships?
Yes.
Lordships, beg to represent the petitioner, your lordships. Lordships, we are challenging the notice issued under 148. Lordships, because
148A or 148?
Lordships, I'm challenging the 148A3 order and the consequential notice issued under 148.
Under 148A.
Yes,
I
sir.
think we have already taken a decision or view have been expressed on that. There is one judgment we dictated in the open court. I think we have taken a particular view. 148A3 and consequent effect of 148.
Verify and.
Please verify. We have already that judgment, brother. My brother remembers more. I remember the the ratio which I have.
148A. Interpret 148.
Madam, we have taken a view. You should go through that judgment. If you still feel that the judgment has not considered many other points or has been wrongly decided, we are very open. If we find that he has wrongly decided, we are bold enough to accept.
Lordships,
But you'll have to convince us.
Lordships, even otherwise, your lordships, I have challenged the jurisdiction on another issue, your lordships. So in this case, what has happened, your lordships? The SSC's husband was deceased, your lordships. He passed away in February 2024. Thereafter, the notice was issued in the name of the spouse, your lordship, but not as a legal heir. May I take your lordships to the show cause
What is
notice?
the difference between a spouse and the legal heir?
Yes, your lordships. So when there's a deceased SSC, your lordships, if a notice has to be issued in the name of a deceased SSC, it should be in the name of the legal heir, stating that it's the legal representative of the deceased, and the PAN number should be that of the deceased SSC.
So spouse is not the legal heir or a legal representative of the deceased.
She is the legal heir, your lordships,
So-
but the PAN they have used that of the SSC, your lordships, as if they are taxing it in her name, and even the notice was issued as if it's in her name. And when we had brought this to their knowledge, they say, no, since you're the legal heir, I want to continue this. But if they want to continue it, they should continue it by issuing a fresh notice in the PAN of the deceased husband, not in the PAN of the legal heir in her individual capacity, your lordships. The notice fails on the PAN.
Is it so fatal that it will invalidate every action?
Yes, your
When
lordships.
admittedly the spouse
Yes.
is the class 1 heir and he inherited the estate of the deceased husband.
Yes, your lordships, because the PAN number now it'll be as if for this assessment year, the legal heirs is individually assessed in her name and it is her assessment, not that of the deceased husband. So the PAN is the problem over here, your lordships.
There is nothing, they will rectify it. There is no difficulty
Lordships,
because there is identity is not in dispute. Everything is not in dispute. Only thing is the PAN number which can be rectified or replaced. Will it
Lordships,
invalidate the whole? Because I understand you will take advantage of the limitation having intervened in the meantime.
no, your lordships, no, your lordships.
Then now the
Lordships, they
period
have
has
3 years.
expired. Period has expired. They cannot reopen.
No, your lordships, they can, your lordships. It's 21-22 only, your lordships.
Okay, 21-22.
21-22 only, your lordships. So this notice
what
has
you
to be
say.
quashed. They
It's a
can issue
minor
a fresh
defect.
notice.
Allowed to rectify if
Lordships, rectification.
What she says, not only rectification is not enough. Entire notice you should recall and a fresh notice to be issued in the PAN number of the spouse. Or in the, PAN number of the deceased.
No, my lord, no.
What is the law? Sure.
My lord, here the
According to her, the deceased is regarded as an SSE and alive for the purpose of, the tax liability.
my lord, as the wife of the deceased, wife of the deceased husband will be treated as a deemed asset, my lord, as a legal representative of the deceased husband. Under section 159.
So he says that is definitely can be done, but the assessment has to be done in the PAN number of the SSC. Means the deceased SSC. I think your contention is this.
Yes, your lordships.
That is what she says. But you have used the PAN number of the spouse.
Well, I have the instructions regarding the PAN number of the, deceased persons and wife of the deceased person.
Because the income was generated by a deceased during that particular, the assessment year. So it was not an income of the spouse. But since he died, the assets or the estate has gone in the hand of a spouse. So they say that now you are liable.
Well, it is a matter of inadmissible donation, bogus donation.
What?
On the section 8.
We are not on merit. We are not on. We are on the legality of the assessment status. In which you have assessed.
What? Tell us what to do.
On the basis of status of the
Anyhow, we have passed an order of any further actions there in that matter. Have we passed? You just go through that.
Okay.
148A, you go through it. We are keeping the day after tomorrow. Come ready with that.
Lordships, stay may be granted in the intervening period, your lordships.
Madam, you waited for such a long time, 2 days. Nothing is going to happen. The heaven will not fall. Don't worry. Yes. Next day after tomorrow.
Of the deceased,
Obliged to
this PAN number, under which PAN you have to assess whether you have correctly done or not. Take that instruction.
Item note 30.
Obliged to
Item 30, my lord, in the first matter, I have entered appearance for the respondent number 1. Though I have filed power that has not come today, but I have filed in 1912, 1909. If my lord will permit me, then I will place for the respondent number 1. I am for the UR kit. I started.
Because we are having only 3 days.
Yes, yes.
Should we go for a lengthy hearing matter?
No, I will not disturb my lord's views, and I
Yes,
have already
just
gathered the information. But
Whether you
only I
go
want
for a
to
lengthy
say.
hearing matter.
Only I want to say, my lord, I am now stand for the UR category because there are 3 categories. Those are confused. Yes.
At this hour.
Oh, sorry, my lord.
If
Yes.
it is
This, my lord, may
open,
keep it to some other day, then address this. Yes. All right. At 2 because my senior from Delhi.
After.
Yes. Yes, sir. But at 2 because my senior from New Delhi is appearing there. So, or ancient.
Who is appearing? Your senior.
Mr.
Oh.
Is there, so only with his consent I will. Can you?
Come next week. Only 3-4 days are left.
Yes.
There are many other matters. They are mentioning the matter.
This is not that resolution matter.
Yes.
This is what a resolution, a reservation.
Because
I think he is the actual
Now one
enter.
Exactly, when my learned friend's client got the benefit as per their concession, now he is happy. But now entire issue is not that one. That I will.
That's why he is taking back seat.
Yes, now he's there.
No, he was taking a back seat.
Yes, he is there.
He is happy.
Yes, he is happy. My Oza is also happy.
Not enjoying the fruit, my lord, because though they have selected on.
Because the illegality committed at the end of the.
Whatever.
Alright.
So one just put that matter. 8, 9, 10, just give it. 13, 14 or 15, any day. 15. 15 will do.
Yes.
15, everybody.
Yes.
No difficult.
And senior is there.
15.
15. At 2 p.m.
2 p.m.
Yes, good.
Kindly have it.
I think 3 p.m. is better.
Yes,
15, not 2 p.m.
Affidavit is already placed on record. That is just make a note.
Affidavits are to be taken on record.
It's already filed.
It's are there. That is our one. That for the record.
Yes.
I will
Yes.
just exactly give a compilation. In the meantime,
Item 31.
Yes.
I think also an order. Proceeding under the Surface Act.
How can an order of the Human Rights Commission be challenged? Do they have the powers to issue any order, or simply they are the recommending body?
As far as Human Rights Council is concerned,
Yes.
that is a different writ petition, not connected to this writ petition. This is just
Because I find some observations, that's why I am asking.
For the first time, he went to the Human Rights Commission, where the Human Rights Commission passed an order, and since that was without jurisdiction and it was not within the purview of the Human Rights Commission, we filed a writ petition and there was a stay. And thereafter, my lord, this gentleman, the opposite party, filed another writ petition before this honorable court, saying that we have sold the property, but there is no passage to the property. But there is no access to the property, so I must be giving back my money. This was the writ petition. In respect of a surface action, though an appeal lies, he did not go to appeal, he came in a writ petition.
No, I am still, because I have not read the fact. So that's why I am saying.
You'll also ask me.
Please tell me what is the fact, how the dispute originated.
May kindly see annexure 93.
What is this? Can you be in a summarized manner?
Summarizing the whole thing.
Yes, please.
This person is an auction purchaser.
Is an auction purchaser.
Auction purchaser.
Means the appellant or the respondent.
Opposite party.
Opposite.
Present opposite party.
Who is a writ petitioner?
Who was the writ petitioner?
Correct. Then,
My lord, for the purpose of sale of a rice mill under SURFACE Act, we published a notice for e-auction.
you are a bank.
I'm a bank.
Financial
I published the
institution.
notice for e-auction sale in all the newspapers.
Correct.
And the condition was as is where is, as is what is, and without any recourse basis.
Correct.
There was a competition. Many people competed.
Correct.
And this gentleman verified the documents and then he competed and he came out with a successful bidder, deposited the money. Thereafter, when we asked him to deliver possession of the property, he went back. He said that since you have not sold me a passage, I will not take it. There is a passage. But according to him, since I have not given him an independent passage, so he will not take it. But so far as this advertisement is concerned, here there was no passage was sold. There is a passage. Because the original
So
owner...
when it was as is where is basis, so he must be aware that where is the topograph, what is the entire...
Yes, that is the whole thing. He verified everything.
Okay, then
my lord, he did not
take the position.
Take the position. Then he went to Human Rights Commission. Human Rights passed an hour. I challenged it and it was stayed here. Then he came here. Then he gave a FIR.
What for he came?
He came that out saying the same passage. That they are not giving me passage.
No, so you have not given a passage. So what for the? What was the relief claimed in the
The relief claim that you return me money.
Oh, return me money.
Interest and all.
Correct. So,
And the Honorable Single Judge directed return of the money with interest twice.
Twice means?
Your Lordship, may kindly see the order. It is a very cryptic order, my Lord. I myself failed to understand what was the meaning of the order. Your Lordship, may kindly see, kindly come to 143.
142.
Conclusion. My Lord, 143 conclusion. First part of the order, your Lordship, may
Para
kindly.
19. Para 19 is against you.
Para 20 is the conclusion.
Para 19.
Para 19 is the decided as against me.
No. Very
Para
interesting.
20.
When I can't 20, 21 and 22. What is this? I have one word in my mouth. I do not want to use it. But can this type of an order be passed? Directing him to deliver the property with the free annexes. Alternatively, he says that they pay the entire amount and interest to be paid till the delivery of the property. So he will refund the entire money which is received, yet he is liable to deliver the property to you after giving an excess. What?
And also you are not kindly.
Third, 22 I have seen, more damaging.
Yes.
How? Can it be done? Yes, tell me.
The respondent number 1, the option purchase.
So, tell me, it is in your favor, sir. You have to support the order. Can it be done? He will be out of pocket the money which you paid along with the interest. He will also be out of the property. He will not be able to do. And third is more damaging.
20 and 21, para 20 and 21 are in alternate.
Please read 21. Please read. The bank shall refund the entire amount deposited by the petitioner along with an interest at the commercial rate for entire period until the physical delivery of the auction property. What does it mean? Tell me.
Either they have to provide us the land or.
I can understand, sir. The alternative I understand. The first direction was that you give an access. Then alternative when he says then immediately amount within a time frame until the delivery of the entire property. From where? What does it mean? If they are unable to give you a property and refund your money, then until delivery of the property means what? They will deliver the property to you also to avoid the interest, and they will be out of pocket as well. Without money, you got the property. Interesting.
I've already deposited the money.
Sir, you are getting back. And you are getting property also. Just imagine. You are getting back the money and you are getting the property free of cost.
20 and 22 are to be read together and 21 is an alternative to that.
What alternative?
If they are giving land, they need to provide the interest for the period. I was devoid of that money, that interest amount.
Sir, I can understand that he says the refund of the money. Now the question would be that once you are an auction purchaser and participated with your open eye, when the condition was the as is where is basis, are you, again, I do not want to use very sarcastic words. You are goes there and see when it is more as in where is basis. The advantages, the disadvantages, then you quote the price. You don't quote the price in air. And this rice mill was in a running condition at one point of time. How they were getting an access. How they were running. Now they have committed a default. Now they have invoked Section 13. After taking steps under Section 13(2), then also 13(4), then 14 took possession. Section Rule 8 of the security interests rules, everything they followed. And then the auction. Can you show us one judgment? I do not know. An auction purchaser can raise this issue and get the money back.
Into page number 113 in parallel. It's given the judgment.
Yes.
It reads that in Haryana Financial Corporation, the Supreme Court in this regard of the perusal of the above provision will show that it was incumbent upon the appellant corporation to disclose the respondent about the non-existence of an independent passage to the union. It was also the duty of the appellant corporation to inform the
What was the nature of the auction? Which one? Which you are referring? Which page?
Page 159.
Yes. This is a single bench judgment. It's a single bench judgment. Is it binding on us? And it is, again I'm saying, had it been in another case, I would have understood. But it is as is where is, whether you can show that there was no passage, you have not given me all this aspect, can you?
Section 55.
55 Act, whatever you read.
right and liabilities of a partner and seller.
When the unit was running, DIC must have given certification to run the unit. So without passage, you meant to say that DIC closed its eyes and gave permission to run the rice mill.
When we applied
What are you talking?
for the mutation,
And as is very basis, you are caveat.
I'm sorry, my lord. May I be permitted, my lord?
No, we are
Only if your lordship.
we are staying the operation of the order.
My lord, may only hear me for a moment, my lord, if I may only.
Yes, we have given your junior the ample opportunity. You can't come at per your own whims and say that you should be heard.
I'm sorry, my lord. I apologize, my lord.
Sorry.
My lord, I only wanted to bring to your lordship notice a factual aspect, my lord.
Whatever the nature of the order is such, it is reconcilable, and we cannot agree to this.
My lord, may I only bring to your lordship one fact, my lord, if that can be permitted, my lord, if I,
Nothing.
before your lordship's sake. My lord, if your lordship has.
How much days delay?
Delay is 4 days.
No, no, there is no delay.
Huh? There is no delay. No delay.
My lord, may I only bring to your lordships the document which has been given to us by the bank. That's the only thing I want.
Please tell us how you can interpret para 20, 21 and 22 of the judgment. Impugned.
My lord.
Please tell me what you understood and what we understood. Tell me.
My lord, if your lordship has, well, para 2021, your lordship says.
Please.
That is the execution part.
My lord.
Please tell us.
My lord, the point here was, my lord, when
I am again asking, please tell us how you can reconcile 20, 21 and 22. Please tell me.
My lord, because there was a statement made by the bank.
Please read that and tell me that what it conveys. Please tell me what paragraph 20 says. Let us.
Paragraph 20 says, your lordship, in light of the foregoing, the opposite party bank is directed to either deliver the property to the petitioner with the ingress and egress rights available for access to the property as shown in the sketch map within 1 month from the date of this judgment. Alternatively,
the property has to be delivered by him with the access to the property.
I bowed on that. Yes.
Now read 21. Alternatively.
Alternatively, the bank shall refund the entire amount deposited by the petitioner along with interest at the commercial rate for the entire period until the physical delivery of the auction property.
How? Tell me. Because until the physical delivery, how? There is no physical delivery which is given by him because you refuse to accept.
No, we didn't refuse to accept with ingress egress, my lord. Ingress egress is the issue, my lord. First,
Sir, the bank is saying that at the time of handing over the possession, you refused to accept it because there was no access. Now, in 21, if the entire amount is alternatively to be refunded with interest, how the interest would be calculated at up to what date? Tell me. Interest up to the delivery of the property to you? So they will refund the money with interest also and also to deliver a property to you. Come to 22 again. Oh.
Disconnected.
Sorry. Can't. The appellant bank
introduced a beneficial scheme for construction of some parts and for
So your writ petition is dismissed.
writ petition is dismissed, my lord.
Why it is dismissed?
And in another batch of writ applications, my lord, the court holds it otherwise, my lord, holding that the process of putting it to e-auction is completely illegal, my lord. That is the judgment, my lord. Subsequently, it has come, my lord. The same, my lord, it is by another coordinate single bench, my lord.
What is this?
This is, my lord, relating to, my lord, construction and distribution of flats in favor of the persons having, my lord, taken policy from the life insurance companies. It's a beneficial scheme, and the scheme was that there will be a draw of lottery, and the lottery winners will be handed over possession at a fixed price. But now we subsequent to that, my lord, we coming under the the zone of consideration, my lord, we applied. We deposited 1 lakh and submitted the form by purchasing the forms at rupees 2,000, my lord. Then, my lord, there was a draw of lottery. The lottery was, my lord, I became successful, and one flat was allotted to me. My lord, if your lordship will kindly turn to page 45 of my brief, my lord, your lordship will find page 45. Your lordship will find, my lord, there is a clear stipulation that the allotment shall be made by draw of lottery in the presence of successful applicants or his or her duly authorized representatives carrying an authorization letter. Otherwise, the allotment of flats will be made by the presiding officer as per their choice of types of flats indicated in the application subject to availability of flats. So this is the scheme, my lord. Now, if your lordship will kindly look at the next page, page 46, my lord. It's a terms and condition of the, my lord, scheme, my lord. Under clause 8, subclause C, my lord, it has been specifically said, my lord, once allotment is decided, it shall not be transferred or exchanged with any other applicants. With these clauses, my lord, now the lottery was drawn. I was, my lord, I became successful in the lottery, and a flat was allotted to me. Thereafter, I was asked to deposit the remaining the balance consideration money. When the matter stood like that, my lord, suddenly the LIC, when I was prepared to pay the deposit the rest of the amount, my lord, suddenly the LIC issued a letter saying that, my lord, there is a notification by the government of Odisha that unless the ROR is corrected, it cannot be, my lord, there cannot be a registration, my lord. So they asked me to wait for some time so that the ROR can be corrected, my lord. Thereafter,
Who is for the LIC?
LIC, my lord.
How can it be done? Initially, it was not the ROR. ROR was a minor issue. The major decision for cancellation was that it is a forest land. And if it is a forest land, there cannot be any constructions. And then you were within your rights to cancel all the entire exercise or entire project. But immediately thereafter, you floated the another tender for the same amount, for the same thing, just making the amount a bit higher.
No,
So put it to auction sale.
no, this was done in 2014. This was done in 2014.
Yes.
And after the allotment was made in February,
Correct.
we had to register the sale count.
True.
But at that time, the Tahsildar objected because the registration cannot be.
Sir, I understand you could not register it, but you cancelled the entire one. Then if you cancelled the entire allotment, then in that event, how can you float a few fresh tender?
We cancelled the allotment. Also, we have wrote in because there is a barrier by the government. So we please take refund of the amount.
Correct.
We intimated him.
Then why you floated again?
But he did not, neither he took back the money nor he.
Correct. Then why you floated again, invited the application?
Because the government in 2024
Yes.
cleared the land that it is not a forest land.
So will you not give it to them because the reason for the cancellation has been over? Will you not?
So therefore,
What you have done with all the participants who were selected at that point of time?
but the construction was in two phases. So for phase one is concerned, we transferred the land. But when we are going to transfer the construction made in phase two, the government raised these objections. So we are undone. So therefore, since they have insisted, why are you not registering it? So we intimated that because of these reasons.
But now the impasse has gone. Now you'll have to execute the deed.
So therefore, my lord, because around 75 persons could not, 75 plots could not be allotted. So we say that because these 75 plots are there, so we said that these plots can be auctioned by
auction.
Very
interesting. Very interesting. How can it be? The scheme was, when this entire construction was undertaken, the scheme was that whoever has taken my policy, they are the only eligible persons who can offer it. And you will give them a subsidized because they were your committed customers.
Yes.
You have chosen him. You have chosen somebody in a phase one. There you have done everything.
So phase one, there was no objection because we transferred.
It is within the same compound, sir.
In the same compound.
So
keeping in view the escalation which has been made during
nothing.
this period.
I don't think so. Nothing. Escalation. Whose default?
Construction was already.
It is your default. You could not get the ROR corrected. Why they will be penalized?
Well, my responsible submission would be, here they have only some giving the registration fees. So mere submission of the registration fees, there was no allotment in their favor.
What are you talking about? There is no allotment. Have you not written a letter to them that you have been found successful? Have you invited their attention to deposit any other amount? Then if your condition does not permit those amount to be deposited, then they have deposited the 10 lakhs rupees.
Well, that is there, but
So 1 lakh. 1 lakh.
Just
1 lakh.
1 lakh.
Yes.
Apart from the first of the.
So far the other cases are concerned, they immediately came before this honorable court.
Yes.
But so far these petitioners are concerned, they neither supplied the account number nor made any correspondence with her. After we have advertised for e-auction, they now come forward in 2019.
Because they were not aware that what is happening. They just thought that there is some problem. You will indicate.
They are in receipt. The cancellation order was with them.
When you have communicated?
They could have in 2014. They have not done any objection. Because this is
immediately put our objection.
Put an objection where?
At annexure.
When?
Immediately when they communicated to me.
2014. Cancellation order is communicated to you when?
To me on in the year 2014, my lord.
Yes. You put an objection?
Yes, then my lord, your lordship will find annex the page 61 by is my objection, my lord. Immediately after
when you filed a writ petition?
I filed the writ application when they decided to put it to auction, my lord.
When?
My lord, it was filed, writ application was filed on. It was filed on 28/3/2005. 25.
What you were doing from 2014, 11 years?
I put my objection. They have never said communicated anything thereafter. Suddenly,
will you not challenge?
Well, I have already put in my objection. I am just satisfying you.
The order of cancellation was already issued to you.
Issued to me.
Now you have given an objection means what? That you have said that no, this cancellation is bad. If they were not doing anything, will you not challenge that order of cancellation?
Bona fide, if your lordship will kindly consider me, my lord. My bona fide was that, my lord, supposing the state government would not have permitted them to, my lord, sell out these flats, my lord. Then what was the reason for me to come before this honorable court? In that case, my lord, I could not have come, my lord.
Has he taken any ground of delay and laches?
No, they have not filed the counter even in the writ application.
They have not taken any.
No. No counter of writ was filed.
Writ application was disclosed with the
Stage of admission.
What?
writ application was hard and disclosed at the stage of admission.
In their pages.
There was no, it's in our pages, sir.
But you have not taken that plea of delay and laches. You have not.
We have filed the reply. I don't feel this.
No, you have taken. You have taken. He has taken. Page 90, I've seen Roman 7. Roman 7.
Page 90, Roman 7, madam.
90.
Yes.
Roman 7. Tell us.
That is the.
Tell us whether it can be. I can give you some judgments. Please go through those judgments and tell us.
Yes, my lord, I will go through, my lord. My bona fide, if your lordship will kindly.
I am giving you. Please go those judgment line of judgments.
Not because the.
Please consider 1969 volume 1 SCC page 110 paragraph 65.
1969
volume 1 SCC page 110 paragraph 65. Consider 2011 volume 5 SCC page 607. Consider 2012 volume 6 SCC page 66 paragraph 14, 15 and 16. 14, 15 and 16. Read come. Sure.
But
Please read the judgment and come.
Yes.
Please read the judgment and come.
There also some of the writ applications were filed after 4 or 5 years.
Sir, please read the judgment what it says.
Go through it.
Yes, please.
Your lordship is calling it.
Day after tomorrow, if you read, come. No difficulty, sir.
Okay.
33.
May I make a small prayer, your lordship? Same, out of the same judgment, your lordship, item 40, 41 is there. Same judgment, say parties are there.
Yes.
The impugned judgment is a common judgment.
Yes.
Out of it, item 40, 41 today, your lordship is there. The writ appeal was in time, but only certified copy was filed at all. So there is a delay.
What is the disciplinary action which is there?
40, 41, serial number 40,
Yes.
41. The same impugned judgment, your lordship. I have given a copy only, my lord. The writ appeal was in time. Certified copy was filed later on. There is a very inadvertent mistake. Certified, but writ appeal was in time.
Yes.
The writ appeal was in time, my lord. Only certified copy of the impugned order I filed later on. That is a mistake I admit. But perhaps item 40, 41, the two IS I filed for that the certified copy I filed little later, but the writ appeal was in time. My learned brother is there. I have given a copy. Serial number 40, 41.
Yes. Which one?
Item number 40, 41, your lordship, arising out of same.
No. This matter he's saying is connected with 41 and 42.
Yes. Item 32. Yes, it is connected to item 40, 41. Wherein your lordship.
No, 32 or 33?
32 matter. Item 40 and 41, two matters are so where the same impugned judgment. Matter. Same impugned judgment.
Oh, we'll consider. Oh, I was just thinking 33. Call. I was
Item
looking at
33.
33.
Item 32, I'm very respondent number 4.
Give your name. That's
33, it's a fresh writ appeal relating to termination of
that is what I was looking at it. Quinn versus Lidham has been quoted.
there is
Very
one-
off-quoted
the allegations
principles of law.
Before I begin, all that I want to say that there are allegations of rape against tribal people. So the allegations are serious. I just wanted to say that in terms of live stream.
Oh, hey.